Eviction is a legal process in which a landlord removes a tenant from their home. In California, a landlord is not allowed to just kick a tenant out or change the locks. This is called self-help eviction, and it's against the law. Instead, landlords are legally required to follow a step-by-step process to remove someone. If you're a tenant, you have rights and responsibilities in this process. When you are a tenant, you have a legal agreement with a landlord. This can be written or oral. When a landlord wants you to move, they say that you violated the agreement or they do not want you to live there anymore. They need to begin the eviction process by giving you a written notice. There are lots of different kinds of notices given for different reasons, for not paying your rent to breaking the lease in some other way. This notice officially starts the eviction process and must include specific information like the amount owed or violation details. If the tenant does not comply with the notice within the specified time frame, the landlord can file an unlawful detainer lawsuit with the local courthouse. This is the formal legal action that begins the court process, and the tenant must be properly served with the lawsuit papers. Most eviction cases follow a similar process. After the complaint is filed, the tenant has to file a written response called an answer. After this, the case is set for a trial date in court. On that court date, the tenant may argue their case at trial, or they have the opportunity to negotiate an agreement with the landlord to resolve the case. If an agreement is not possible, the case will go to trial. After the trial, if the landlord wins, the landlord will ask for a lockout date from the local sheriff's department. On this date, the tenant must have all of their property out of the residence. If the tenant wins, they are allowed to stay, but it is very difficult for tenants to win at trial. However, there are opportunities to try to resolve the case before going to court, right after you receive the notice. If you disagree with the notice, for example, maybe you already paid your rent, reach out to the landlord, ideally in writing, and tell them that the notice is wrong and why. If the landlord still thinks there's a problem, you have 3 options. You can defend yourself in court, negotiate an agreement to move out, or you can give the landlord what they want, even if you disagree. This will prevent you from being evicted. You can then go to small claims court and ask for the money back. Your odds of success are probably higher in small claims court than in the eviction court, called unlawful detainer court. If you can't afford to pay rent, then it's going to be very hard to challenge the eviction. Your best bet is to try to negotiate with a landlord to get additional time to pay your rent or resolve the issue in some other way, or in the worst-case scenario, find a new place to live. Eviction is a complex area of law and cases can be challenging. The earlier in the process you reach out to a lawyer, the better chance you will have of getting a resolution that you want. If you are being evicted, or think you might be, reach out to Inland County's Legal Services to see if you are eligible for representation.